Evander, Judge, presiding officer setting business for this court. Your Honor, your attention, you shall be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Who does it say that I am?
It says here, Judge Griffin.
Okay.
I have Judge Palmer's glass here. Palmer, do you want to?
Okay, good morning. Welcome to a session of the 5th District Court of Appeal. We have 3 cases scheduled for this morning. The first is a criminal case, so each side will have 15 minutes. And the next 2 are civil cases, so each side will have 20 minutes. Just when you come up here, advise the presiding judge how much time you want for rebuttal as far as appellant's counsel, because we will be doing a panel change after the first argument. Judge Griffin will be presiding for the last 2 cases. I'll just be presiding for the first. If you have any cell phones now, make sure you turn them off so the oral arguments are not interrupted. Let me go ahead and introduce the other members of the panel. Seated to my right is Judge Alan Lawson, and to my left is Judge William Palmer. And as I mentioned, Judge Griffin will be sitting in on the last 2 cases. Also, after the second oral argument, we'll be taking a break. We invite the attorneys to join us in the attorney's lounge for coffee at that time. Okay. All right, we'll go ahead and start with the case of the state of Florida versus Annette LATONA.
May it please the court, I'd like to reserve 2 minutes for rebuttal.
Okay.
My name is Chris Davenport, and I represent the state of Florida. This is an appeal from an order granting a motion to dismiss 3 counts of possession of oxycodone and morphine. The defendant filed a motion to dismiss, arguing that she was authorized to possess these controlled substances because she had a durable power of attorney from the individual who had the prescription for these items.
Let me ask you this. If there had been no traverse in this case, would the trial judge be correct in granting the motion to dismiss?
If there had been no traverse or the state had no reason to question the durable power of attorney and the scope of it, then yes, I would say she would fall under the prescription defense and have an innocent explanation for having these items.
Okay.
But there was a traverse, and in the traverse, the state asserted, as a sworn factual matter, that they had spoken to the person who had the prescription, and he said that this woman was not authorized to have these items. Also, the circumstances where she was found outside the crack house.
You cite correctly the law that says that it's that the principal determines the scope of the agency relationship,
right,
not the agency. But isn't it that determined based on the document that the principal signs?
Right, it is.
I mean, legally, if we had a real estate transaction and I gave you a power of attorney authorizing you to sell a certain property or a certain location, and you did that, I couldn't later come back and say, well, she didn't have the authority to do that if the document was in effect and had never been revoked and you were given that authority in the document. Isn't that correct?
If I had the specific authority in the document and it was a civil suit, I mean, that document would be controlling. In this case, though, it's a criminal case, so we're not suing her for breaching the contract, and he's not bringing a civil claim against her. This is a criminal case where the issue is a little different. It's did she have an agency, and was she acting within the scope of that agency? Because when you look at the way...
But isn't that determined by the document that creates the agency relationship?
I think that's evidence of whether or not she had an agency relationship, and we're not disputing that she could act as his agent. What we're disputing is whether she was acting as his agent at the time she possessed this medication. Now,
well, if the power of attorney and the medical authorizations authorized her to possess those medications on his behalf, are you saying that he, in essence, revoked that authorization, or are you saying that he never gave it in the first place?
I'm saying first of all, there's no specific authorization for her to have his prescription.
Well,
But
that's
admittedly,
why I asked the first question about whether if there had been no traverse, she would prevail, because are you disputing that the power of attorney and medical authorizations gave her the power to possess those medications on his behalf in the first place?
no, I'm not. I think that's clearly relevant evidence. I think that if that's all we had was this durable power of attorney, and we didn't have the circumstances where she was arrested or his statement that she was not supposed to have the medication, that would be a valid, innocent explanation for her possession of these items.
So if those documents gave her the power to possess the medications in the first place, or the drugs in the first place, are you saying are you arguing that he revoked that authorization?
Yes.
All right. Is there anywhere in the traverse where it indicates that he communicated to her that he had revoked that authorization?
And not specifically in the traverse. I'm also arguing that she was not acting within the scope of that agency, though, and she had essentially converted them to her own use. Because he didn't just, he said that she wasn't supposed to have them. He had all his other medication. These were the only items that she had. And when you look at where she was found and the statements that she made to the police officers, she was found by a crack house. She had no money, but she told the officer she was looking to get some crack. And then she said, oh, and I wasn't going to trade these pills, which, is questionable under those circumstances. I think given all of those circumstances, a jury could reasonably conclude that even if he had given her permission to have these, she didn't have permission at that point, and she had converted them to her own use at that point.
So are you saying that the state just mischarged her, should have charged her with possession with intent to sell or deliver?
No, I think just possession was enough. I think they could have charged her possession with
really
intent
what you're relying on is you're saying the evidence is sufficient to show beyond a reasonable doubt that she had an intent to use those drugs for her own purposes.
I'm saying that
because otherwise, what if she had been coming from the pharmacy having filled his prescription? What would you say then?
And she had this durable power of attorney,
right,
and
right.
it was purely innocent circumstances, I would say that the trial judge would properly dismiss it under those
But what if she
circumstances.
filled the prescription so that she could go trade them for drugs herself?
If there was evidence of that,
Right.
then I think that she wasn't acting within the scope of her agency.
So you're saying that you're really basing your argument on the evidence of her subjective intent at the time that she was found with the pill bottles.
I think it's the evidence of was she acting within her scope of her agency. Now, the fact that Mr. Holmes said she wasn't supposed to have these pills, I think is evidence that she wasn't acting within the scope of her agency.
Well, let's go back to the pharmacy question. If she's walking out of the pharmacy holding these two pill containers, and she gets stopped, and you use the same traverse that he says, well, she's not supposed to have them.
If he
You win or
had
lose
said
now.
she wasn't I didn't want her to go fill this prescription, I think it becomes a jury issue.
But would he have to communicate that to her? He's given her a power of attorney that says, in essence, that she has, implicitly, that she has the right to go pick up his pills for her.
Right.
So she does, and on her way back from the pharmacy to his house, she gets stopped, and she's got these two pill boxes. So she files the C4 motion saying, hey, I have a power of attorney, I have medical authorization, and he says she's not supposed to have a medication, but he doesn't say he communicated this to her. Does she win the C4 motion? What I'm doing is I'm getting rid of the facts about
The crack
being near a
house.
crack house and all
Right.
that.
I think that's a hard question without knowing how'd she get the prescription. If he says, I didn't give her my prescription, she has this durable power of attorney, but I never wanted her to go get my drugs, I think that would be enough to raise a question for the jury. If it comes out at trial that, it was laying on the counter and he was taking a nap and she'd gotten it 10 times in the past, so she took it and figured that that was what he wanted, and it was never communicated to her that he had revoked that in any way, then I think that would be a JOA.
Well, this was a general power of attorney, right? It didn't
Yes.
specify anything in particular she could or couldn't do.
Correct. That's correct.
So there could be lots of factual situations where you'd have to sort out what's within the scope of that authority, right?
Yes.
I mean, if she had a general power of attorney and he's asleep in his bedroom and she pulls the U-Haul up to the front door and empties all the furniture into the car without him having revoked it or saying, no, you can't do that, she could be charged with possession of stolen property, couldn't she?
She could, yes. Because that would be acting outside of the scope of her authority as his agent.
And did the traverse, in essence, say that that's what she was doing, acting outside of the scope of her authority?
The traverse said exactly that. They said that whether or not she was acting as his agent is a legal conclusion, and that we have evidence contradicting her theory that this was all done within the scope of the power of attorney, including his specific testimony that said she wasn't authorized to have his medication. Now, under the defendant's position, she could do anything that he could do under this durable power of attorney. Under that theory, she could take his pills because he was authorized to take his pills. Clearly, she couldn't do that. Even if he said, go ahead and do that, the law limits how much authority he can give to her, too. These are controlled substances. This isn't, just routine tangible property. Under the law, you can only delegate so much authority. So the question in this case is whether or not she was acting under proper delegated authority and had an innocent explanation for having these pills. And all we're asking is that this be allowed to go to a jury and they can evaluate the conflicting evidence. And again, it is conflicting evidence. He says she wasn't supposed to have it. She says that this is why she had it. She was taking care of him.
What's the evidence that she was going to use it for an improper purpose, other than asking the jury to believe that subjectively she was going to do so?
The evidence is that she was looking for crack cocaine, didn't have any money, but she had these pills. And he said she wasn't supposed to have them. But again, we don't have to show she was using them for an improper purpose. We have to show that she was using them outside the scope of the agency.
But her agency allows her to have it in her purse, right?
If she's acting within the scope of the agency, yes. If she's gone outside that, if she had taken the pills and gone on a trip to Alaska for 6 months, that would be outside the scope of her agency. And in that case, she can't have them properly. So all we'd ask is that the jury be allowed to evaluate this evidence. Thank you.
Good morning. May it please the court. I'm Chris Quarles, and I represent Ms. LATONA. First of all, it says in the document itself, the durable power of attorney, that revocation must be in writing. The trial judge relied heavily on that in granting the motion to dismiss.
Could she be charged with possession of stolen property if she took his property away, but there wasn't a written revocation?
I don't believe so.
Okay, so she could clear out his bank account, they couldn't do anything about it without a revocation. She could take all his furniture and take it off, and there'd be no criminal charge, if possible.
I would say so, unless subsequently they can prove that perhaps the best traverse would have been that this durable power of attorney was obtained by fraud, and there was no indication that it was.
What about a traverse which says what she's doing is beyond the scope of authority? So what if she cleared out the house of furniture and they got a traverse from the person who gave her the power of attorney who said she didn't have, I wasn't giving her authority to take my furniture, that had nothing to do with why I gave her the power of attorney. Would that be enough to go forward?
The durable power of attorney is pretty much all sweeping. That was the argument below by the defense lawyer. He said she could sell his house, and I think under the right circumstances, if they showed fraud, if she converted, there are some cases that talk about how someone exceeded the durable power of attorney where they were not acting in the best interest. There is a best interest clause, but it would, as they pointed out below, it would have been a different matter if she had been selling them or trading them for other drugs, but there was no indication of that. She could do, and there was a health care.
Well, I think the point is that there are facts that a reasonable person could infer, from which a reasonable person could infer that she was going to trade them for drugs. She was there. She said she was going to buy crack or obtain crack. She had no cash.
She could have traded the car. She could have traded sex. She could have traded anything of value in the car.
So if it was his car, it would have been all right? And she couldn't have been charged if she'd traded his car?
That probably
Because
would,
that was within a broad power of attorney?
that might constitute fraud, but
So your argument is that if the facts were sufficient to show that she was acting outside the scope of her agency, in other words, if she had completed the transaction or if they had arrested her after she offered to
Correct.
to buy it, but the facts just don't rise to that level.
And that was conceded below by defense counsel, yes. If perhaps, and there was some indication, well, maybe they stepped in too soon. They needed for the crime to occur before they could actually step in and arrest her. She can have those, and there are reasons people have durable powers of attorney. There are some clues in here. We don't know for sure, but there's some clues in the police report, just like her statements to the police.
Well, I would think that there's a pretty decent legal argument that unless the state presented evidence that the authorization was revoked, which they didn't, that it was the motion to dismiss should have been granted. But if your theory is just that there's evidence, but you don't think it's sufficient to show that she was acting outside the scope, I'm wondering why the fact that he said she shouldn't have had him and the circumstances under which she was caught with the or found with the drugs wouldn't be sufficient to create an issue of fact on that.
Well, I was getting that point. There are reasons people have durable power of attorney. He obviously needs a caregiver. She has an advance directive. She can make a decision to end his life if he's unable to make that decision, pull the plug. She's got a health directive where any health issues, he directed everybody to talk about his health issues with her, not him. He's obviously got some incapacity. And one of the things he said, in addition to saying there's no reason she should have my medication, the police report also indicated he was unable to fill out a written statement, and they gave up on that. The police report also said that she had been giving him his morphine daily. He did not remember getting any oxycodone lately, but there again, he may be confused, poor memory, and that's why he needs a durable power of attorney and a caregiver.
And it just sounds like you're saying that's an additional reason why this is a factual issue.
Well, but she's throwing in factual issues, so
Right, because she's saying it's a fact
I'm
issue that needs to
rebutting
go to the jury.
Well,
That's her argument. And it sounds
I
like
think-
you're agreeing that there are lots of facts that go into this decision as to whether she was acting beyond the scope
But
of
the
her
durable
agency.
power of attorney trumps all that.
Well, what about her example? What if she went off to Alaska for 6 months and took his meds with him, but there's been no revocation of the power of attorney? That's okay? She can't be charged, even though there's obviously no connection between providing the medicine for him because she's up in Alaska with all the drugs?
I believe that, no, they could not charge her because that might have been inadvertent. He can always get another script filled, and unless they show she was using them or trading them or selling them up in Alaska, I think that's a proper C4 motion to dismiss, should be granted. And there were specific duties listed in the durable power of attorney, but there was also an omnibus clause which said the inclusion of specific areas does not limit or exclude other areas by failure to include them. That's at page 63 in the record on appeal. There was also, as I mentioned before, there was an attached notification on health care providers that they should deal with her. Also, the judge relied heavily on the fact that it was revocable only by written revocation, not oral. And she stood in his shoes. She could do anything he could, unless...
I have to ask you about this. You close your brief with a quote from a civil case, McNamara versus McNamara, that says, "In reviewing the trial court's decision, we take the facts most favorably in support of the trial court's decision. The findings of the trial court come to this court closed with a presumption of correctness." That's not the standard we have here, is it?
Well, this is a de novo
Right.
issue. Yes,
Right,
you're
so-
right. But certain facts that he found, for example, that she had done nothing unlawful with the pills when she was pulled over, I think that's...
Well, I mean, a judge isn't allowed to make factual determinations in determining a C4 motion.
In determining what was alleged in the motion to dismiss and what the state denied. I mean,
He's looking at the motion. I mean, we can look at the motion just as well as the trial court can.
I so seldom get to use that, Your Honor. I always
You just
have
had to throw it in even if
when
it didn't
I'm
apply.
an appellee.
Okay.
Let's see. But the judge used a good analogy. He said, trial judge said, well, if I've got money in my pocket and I'm driving in the hood and I'm thinking about buying some weed or some other drug, and I get pulled over, I haven't decided yet, I haven't done anything yet, because I have possession of that money, can they charge me with intent to possess drugs? And the prosecutor said yes. Under that scenario, he was equating her possession, legal possession of the prescription medication belonging to her charge as a caregiver. That possession alone was enough to charge her with the possession of without lawful authorization from her as an agent from her caregiver. Her charge rather as a caregiver. I think that the bottom line is whether or not the state traversed with a material fact in dispute.
What's the relationship between the standard on the motion to dismiss and a motion for judgment of acquittal or a motion to set aside a verdict after trial?
In a criminal arena?
In a criminal case, yeah.
Motion to dismiss is that the undisputed facts do not allege a crime. Motion to set aside a verdict, I think the judge could find that, I believe there's no substantial competent evidence, or it could be a material error that the judge feels is of the opinion that it affected the verdict. Of course, that would be subject to appeal by the other side if he does set aside that verdict or grant a new trial. And what was the third?
J-Way.
Motion for judgment of acquittal standard is that if the state has presented substantial competent evidence to prove each and every element beyond a reasonable doubt. And that there's no reasonable hypothesis of innocence that could be construed.
It seems like you're making a really good JOA argument that this is a circumstantial evidence case with respect to her subjective intent, which is what the state's relying on to show that she was acting outside the scope of her agency, and that there are other reasonable hypotheses. I mean, she could have been trading sex, or she could have been getting drugs on credit, or who knows what. I mean, it wasn't. There could have been other explanations for her being there than the fact that she was going to potentially trade the drugs for the crack cocaine. So, given that, the judge would ultimately have to JOA the case. But I'm curious. I mean, I don't know that that's really the standard at this stage of the proceeding.
You're right, and I think all that discussion was looking down the road. I mean, they had not reached the point where all those scenarios were going to be possibly arise. But just her possession of his prescription medication, which by the durable power of attorney and the health care provider attachment, she even has his medication card. She has his health insurance card. She's authorized to use those.
But on the dismissal standard, if there's a factual dispute at all, doesn't the case go beyond?
But there's no true factual dispute. This is all supposition that we're talking about. Well, maybe she was going to do this. Maybe she was going to trade them for crack cocaine. But that's all supposition. There's no evidence.
I mean, she presented evidence that I had the authority to have these drugs, and then the state presented evidence that she was acting outside of that authority, and you can see that if she was, then they could charge her and convict her of possession of cocaine.
I don't think they presented any evidence to show that she was acting outside of authority.
Well, sure.
That was just speculation. All speculation.
Let me ask you this. In the brief filed by the state here, there's no mention of the crack cocaine and all this. I mean, the sole thing argued in the brief is that Mr. Holmes will presumably testify at trial she did not, in fact, have his permission to take these pills, and she was instead using them for an illegal or improper purpose. And the facts only discuss the state attorney's interview of Mr. Holmes. Was the argument made today by Ms. Davenport, was that presented to the trial judge, or was the argument below only as to Mr. Holmes not having given her the authority to have those?
It was mentioned below, and I believe she addresses it in her reply brief, if I recall. But I may be wrong about that.
Well, let me ask you this. If the ward were to testify, I told her not to leave the house with any of the drugs. There's no reason for her to leave the house with the drugs. But he didn't revoke the power of attorney. He didn't in writing limit it, but he specifically told her not to leave the house with the drugs. and she did. Would that subject her to criminal charges because she was in possession and it was outside the scope of?
No, because it was inside the scope of the written power of attorney, and that's what counts. He obviously needs a caregiver and a durable power of attorney for a reason. I mean, he may tell her not to leave the house with the medication because he doesn't know what's best for him. That's what this is all about. So no, I think she can legally leave the house even though he tells her otherwise. If there are no further questions, thank you.
Just briefly, Your Honor, on the statement of facts of the brief, I note that the prosecutor did point out that she was picked up by the crack house.
Right, but in the
voluntarily,
argument, would you agree that in the argument, in the initial brief, you only discussed Mr. Holmes, having not given her authority to possess those?
Right. I mean, I argued she was outside of the scope of her authority, yeah, and I did point specifically to his testimony. I didn't mention the crack things. I mentioned it in the facts.
Let me ask you, on the Alaska example, would it matter if she was picked up on the first day in Alaska or buying tickets to Alaska, or whether it was arrested after she'd been in Alaska for 6 months?
I think it would matter to the jury. I think just the fact that she was taking his pills to Alaska would be enough to overcome a motion to dismiss. Whether or not it would be enough to overcome a JOA would depend on a whole lot of other facts. Let me also just mention briefly that under the power of attorney, she has an obligation to act for the benefit of the principal. So she can't take all of his items out of the house and sell it and then go gambling with the money. She has to act for his benefit, and when she doesn't, she is going outside the scope of the power of attorney. He did not give her the right to gift everything to herself. Some powers of attorneys do that. This one does not. Not that he could have given her the right to gift these pills to herself, and that's prohibited by the statute. So we would ask this court to reverse.
Okay,
Thank you.